Hi, Cyber Law class. This is Professor Opterbeck, and in this class we are going to talk about international human rights in cyberspace. And I'm calling this part one, although in a way it's really part 1A or 1B, I suppose, because we've talked about this in the context of the United States previously, and we really set up our discussion of human rights and civil rights and cyberspace, talking about U.S. computer crime law and about the Fourth Amendment and the Fifth Amendment and Section 230. And now we're going to look more internationally, and in particular we're going to look at Europe and at other countries in the West or the global North. Next week we will look at countries outside of the West and outside of the global North. And a theme that I'd like you to keep in mind is within liberal democracies, it's really difficult, as we've seen already, to balance the concerns of liberty, civil rights, and security. And we've seen already how some of that balance we've tried to play that out in the US. And we'll see tonight how that balance gets played out in some ways in Europe and in other liberal democratic countries, in some cases with laws that are perhaps more stringent and more compromising in a sense of civil rights than in the US. But then next week when we look at countries outside of liberal democratic regimes, we'll see even stricter controls over the internet. And the question we have to ask ourselves is, to what extent is this a difference of degree, and to what extent is this really a kind of qualitatively different approach? And I think that's an interesting and sometimes contested or difficult question for us to answer. Before we get into the details for this week, I have to ask you, how are the papers coming along? They are due soon. You can't really put this off too much longer. You really should be working on drafts at this point. This is a very significant component of your grade. If you have questions, if you have an outline you want me to look at, if you want to discuss some aspect of your topic, I'm available to do that. But just a friendly reminder to keep going on your papers. So we've already featured this question as we've talked about human rights generally, and as we've talked about the question in the US. But these big questions for liberal democratic constitutional regimes, the internet is a key part now of our democratic infrastructure. Our free speech rights, our rights of association, our communications with each other, our economic activities, all of these depend on the internet. But we have a really particularly difficult problem after the 9/11 era, as we've seen in the US and also internationally, in dealing with the problem of international terrorism and also dealing with a complex of things we call hate speech. And then relatedly, we have questions about the nature of internet surveillance, about cybersecurity, and about the role of the big technology platforms in implementing these things, and the relationship between those big technology platforms and the governments that are supposed to be ensuring our civil liberties. Now, just to refresh your recollection about our discussion in the US, we spent a good amount of time on the issue of speech and association, talking about the U.S. First Amendment and then the Communications Decency Act, and the role that the Communications Decency Act, Section 230, and the role that the Communications Decency Act, Section 230, plays in immunizing U.S. internet service providers and social media companies from certain kinds of private law claims for the content that they host. And we've discussed the possibility of amendments to Section 230. We noted that SESTA and FOSTA were enacted into law, which to some extent limit the Section 230 immunity for certain kinds of sex trafficking. And we've discussed other possible amendments to Section 230 that have been proposed and whether those are a good idea or not. As we move into the European context and into the context of liberal democracies outside of the United States, very interestingly, they don't have something like Section 230 of the CDA. And part of the argument we have about Section 230 in the US is this question of whether it's really necessary, given that that immunity doesn't exist in the EU or in the UK. Now, some people suggest that it's a really different analysis because in most of the civil law countries in the EU, the law of defamation and other private law claims are not potentially as viable as they might be under US law, so the shield isn't quite as necessary. Now, of course, the UK, being a common law country, does have very robust defamation law. And so the argument there isn't exactly the same. But there's also an argument that, well, the big tech companies have grown up in the United States. And perhaps one of the reasons that these are US companies is the fact that at least in their corporate life within the US, they have the benefit of Section 230. But of course, it's not clear whether really Section 230 is part of that dynamic or whether that has more to do with other policies, with other economic factors that perhaps aren't even directly law governed. Now, one thing to keep in mind as we are looking at all of these questions of cybercrime, and we have seen that, of course, cybercrime is an international phenomenon, but there is no international criminal cyber law. In fact, as we've said previously, except in some very limited senses dealing with crimes against humanity, there really is no international criminal law at all. Criminal law, for the most part, is left to national and local law. And there's an international criminal court that is really mostly dealing with war crimes, but there's no international court or international tribunal that's dealing with cybercrime. There is a treaty that dates back to 2001 that I asked you to skim through, which is the Budapest Convention on Cybercrime. And the Budapest Convention does commit the member states to that treaty to agree to minimum standards for their national computer crimes law. And minimum standards is a common way for a treaty to help coordinate the law in different areas of the law across different countries. So the treaty does not mandate what national law must contain in specifics, but it does say that national law must contain at least this much. And if you look at the specific minimum standards in the Budapest Convention, you'll see that they're pretty consistent with the U.S. Computer Fraud and Abuse Act and with the EU computer crimes law that we have already looked at. It also establishes minimum standards for process for obtaining electronic records, and that includes subscriber information, it includes static content information, and it includes real-time content interception, in other words, wiretaps. And we have seen how U.S. law has specific provisions consistent with the U.S. Fourth Amendment about search warrants. We saw in the Carpenter case questions about the scope of search warrants for certain kinds of electronic information, and we've seen the Electronic Communications Privacy Act for certain kinds of orders for subscriber and other content information, and we've talked about the FISA statute and the issues about surveillance there. And so other member countries to the Budapest Convention must similarly have law that, within the context of their own constitutional guarantees of privacy, have to cover that. The Budapest Convention also includes principles of international cooperation in criminal investigations, and including mutual assistance. So mutual assistance is the idea that, let's say the U.S. Justice Department is investigating cybercrime involving actors that the U.S. Justice Department has reason to believe are located, let's say, in France. The U.S. government is not able directly to serve legal process in France. It's not able to serve a search warrant for facilities located in France. It is able to serve a search warrant in the US that might have some extraterritorial effect, but if it wants to serve a warrant in France, it's got to use process in France. Well, how does it do that? The only way to do that is if there is a treaty regime that establishes mechanisms through which the US Justice Department can go to French authorities and ask the French authorities to cooperate and perhaps to domesticate the US search warrant into a French warrant and to proceed from there. And that's exactly what the Convention on Cybercrime requires. Now we'll see that there's a proposed amendment to this convention that has not yet been adopted that would expand some of these cooperation obligations. And if you speak to people in the Justice Department or the FBI and in law enforcement in the US, they will say, yes, these MLATs, these mutual legal assistance treaties are helpful, but they can be very clunky, they can be very slow moving, their effect can differ from country to country, and they argue that this procedure needs to be streamlined and made easier. Now, certain civil liberties groups argue that the more streamlined, the easier you make this, the closer you get actually to international internet surveillance. And this raises a really interesting question about internet governance in relation to national law. So, are these treaties really creating a kind of quasi-international privacy surveillance criminal law or not when we talk about the internet? Now, I asked you to look specifically at Article 35 of the Budapest Convention, which establishes a 24/7 network for immediate assistance. And you'll see when we talk in a few moments about the most recent proposed addendum to the convention that there are proposals to beef this up as well. And again, this is an area of real contention between some law enforcement and some civil liberties groups. The Budapest Convention, the basic convention, has been signed onto by numerous countries, including the United States. And so this is a broadly applicable convention. Now we will talk about an existing addendum to the Convention on Hate Speech and then the proposed further addendum. And we'll see this protocol on hate speech adopted in 2003, which I also asked you to look at. This is something the U.S. has not signed on to. And the U.S. has not signed on to this specifically because the U.S. says that its commitments under the First Amendment, its civil liberties commitments regarding freedom of speech, would not allow it to sign on to this convention regarding hate speech as it is currently structured, whereas most of the European countries have signed on to the convention as to hate speech. And so we'll talk about this additional protocol a little bit later. I'll show you some examples of German law and French law and Australian law that have different perspectives, different takes on relating to terrorist or hate speech online than we currently do in the United States. So the additional protocol, as you see, Article 3 requires, again, it's a minimum standards, requires national governments to adopt legislation against distributing certain kinds of material, racist and xenophobic material. And see, this is, under U.S. First Amendment law, this kind of term is too vague and could potentially be protected speech under the First Amendment. We've seen that the First Amendment is really broad, even when it comes to obscenity. We've seen that child pornography is not protected speech. But, racist speech, xenophobic speech is speech that, any kind of civilized person within the U.S. ought to agree is bad speech. But nevertheless, it is likely to be speech that's protected under the First Amendment, so long as it's not directly inciting violence. The protocol would require a civil remedy for hate speech. It does include kind of carve-outs that can be adopted into national law based on the national law's view of free speech principles. So this, even though the U.S. has not signed this, it still does, for other countries that have, create specific national law carve-outs for free speech questions. But notice that it does require, subject to those potential carve-outs, countries that sign on to it to make racist or xenophobic threats a criminal offense. Now, in the U.S., as we have seen in looking at our law on cyberstalking, a true threat is something that is not necessarily protected by the First Amendment. So again, U.S. law could be consistent with this, but the U.S. has still thought it too broad to include specifically what a racist or xenophobic threat might mean. It also goes even further, and this is something that certainly U.S. law under the First Amendment almost certainly would not allow, which is to require criminalization of a racist or xenophobic insult, or at least to allow the criminalization of a racist or xenophobic insult. And that goes much broader than U.S. law under the First Amendment would really allow. All right, and also applies to activity that would relate to acts of genocide or crimes of humanity, that is cybercrime activity that would relate to acts of genocide or crimes against humanity. In recent years, the EU has really tried to ramp up its legal oversight of social media and other content providers relating to terrorist and hate speech and xenophobic and racist speech. In March of 2018, the EU published what it called illegal content guidelines. Now, these guidelines are not a directive, are not a regulation, are not actually binding law, but they were issued to the social media companies as sort of suggesting here's a way you can properly cooperate with law enforcement, and also kind of suggesting that there might be further directives or regulations coming along these lines. And the concept behind this is the idea that the providers should have some kind of responsibility, a moral responsibility, if not a legal one, to remove content that is deemed illegal under national law. And so among the guidelines includes the content providers having procedures so that individuals, both working for the companies and who are part of the social media community, can flag content that comes quickly to the attention of the company. Tools and technology that allow the company to remove illegal content. Again, in particular, the concern is terrorism content as well as child sexual abuse material. And tools, proactive tools here, you should hear artificial intelligence, you should hear automation that they're asking the companies to implement. Safeguards, so they do want safeguards for users whose content is removed, and that includes some human oversight in the process. So they're asking the companies to use automated tools, but they're also asking the companies to have some human oversight to double check, and closer cooperation with authorities. And this question of how closely the companies are cooperating with law enforcement authorities, as we've seen, is always a fraught question. This piece, this 1 hour rule within these EU guidelines, was a particularly controversial one. And what they were asking is that if it is terrorist content, that the provider should have the ability to remove that content within 1 hour of being referred, that whether it's by a user or whether it's by a government authority, that it is terrorist content. So that was pretty controversial, but this is something the EU has requested of the social media providers. Now, I mentioned that there is a first additional protocol to the Convention on Cybercrime to which the U.S. has not acceded. There is now a proposed second additional protocol to the Convention on Cybercrime, which I think the U.S. would likely accede to. And this is currently, its most recent draft is May 2021. So notice this one is not yet adopted by anyone. It still is in the proposal stage. And what all of this is about is trying to beef up the notification and reporting and cooperation requirements in the original protocol, in the original Budapest Protocol. And some have called this a cloud amendment to the Budapest Protocol, because effectively what it's recognizing is that the world in 2021 is very different than the world was in 2001 in terms of how information is stored by different providers, which is usually broken up into multiple pieces and stored across different borders. And so this would do a bunch of different things. It would require providers to domain name providers, domain name registrars, to keep accurate information and to supply that identifying information of who's registered to a domain name upon request. This has proved to be pretty controversial with some civil rights groups who are arguing that it would completely destroy the ability to remain anonymous online. And remember, this is why we looked at that on the internet, no one knows you're a dog cartoon in the very beginning. This is a big issue now. The requirement for service providers to provide subscriber information, this is consistent with the Budapest Protocol, but would sort of beef up and speed up some of those procedures in Article 7. Article 8 would allow for a easier way to domesticate an order for subscriber information. So remember, I was talking about those multiple legal assistance treaties, and sometimes they're clunky. So one of the ways in which they're clunky is, it's relatively easy under U.S. law and under the law of many European member states within the jurisdiction to get subscriber information, not content information, from a service provider. But if you get that, that Section 2703D order under the ECPA in the U.S., and then you find that the person has an account with, a company with Facebook in France or something like that, it can get a little tricky about whether you can implement that order as to the French information. And so instead of having to get a more difficult to get MLAT, this would make getting that subscriber information order domesticated quicker and easier. Article 9 would require expedited disclosure of stored information without even a request for mutual assistance. So Article 8, the speeding up of the mutual assistance obligations, is, again, itself somewhat controversial among civil liberties groups because it starts to look like you're creating a more internationalized criminal procedure authority for cyberspace that's different from regular space. But Article 9 even more so, because now you're saying simply upon a request without a formal mutual assistance obligation, if there's some expedited reason for it, so an immediate terrorist threat, an immediate threat to health or safety, the law enforcement authorities say we need this because we don't even want to have a 24-hour or a 48-hour delay to domesticate an order. The civil liberties groups say anytime you see expedited or emergency, that creates that loophole you can drive a truck through, which we talked about in connection with the FISA authorities. Article 10 sets out the procedures for emergency mutual assistance. You don't need to worry about the details of that. But just notice there are some set procedures, but they're relatively simple procedures to put this emergency authority into place. Article 12 establishes some procedures to establish joint investigative teams. There already are plenty of joint investigations, say between Interpol and the FBI, that go on, and Article 12 would formalize some of that and make some of that a little bit easier. Article 14 is, something that law enforcement advocates of this additional protocol will cite to the civil liberties groups because it does include protections for personal data, and many of those protections are similar to the privacy protections that exist in the GDPR, in the European Data Privacy Regulation. The question still, though, for civil liberties groups is, are those really adequate, first of all, to maintaining the further disclosure of that information? But on the front end, even the GDPR allows, of course, the use of legal process. Does it really guarantee the basic fundamental rights of privacy when it makes it much easier for the government to get that information in the first place than it might otherwise be? And is it really, again, creating this kind of multinational or international regime for cyberspace that is exceptional and doesn't necessarily exist the same way in the physical world? So let's now talk about the national law in some specific countries, and we'll start with Germany. I didn't have you read this whole statute because it's a little bit long, but I'll kind of summarize it, and it's been called the NetzDG law. And you can see in the summary here of Section 1 of the NetzDG law that it applies to basically all social media companies. And in Section 3, it requires those companies to have a procedure for handling complaints about unlawful content, and it requires them to remove or block content that is manifestly unlawful within 24 hours, or that is just unlawful within 7 days. So putting an obligation on the service provider to affirmatively block or remove content is a strong step that can be taken in national law. You could say that for child pornography materials in the US there is such a requirement because those materials are contraband. But in general, content that is purported to be hate speech or even terroristic content, this kind of affirmative obligation is not what we normally see in US law. So this is a kind of strong step. And then this distinction between manifestly unlawful and unlawful, obviously, regardless of the definitions in the law of what that means, is going to be really difficult for the social media company or service provider to figure out. It's going to require some lawyers making some legal judgments. And frankly, as a lawyer, I'm not even sure what manifestly unlawful versus it's either unlawful or it's not. But the 24 hours is a very short turnaround time, and so you can imagine that if you're in compliance in say YouTube or Facebook as it relates to Germany, you're going to probably err on the side of caution in removing things that quickly that might fall under this provision. The statute identifies what unlawful content means. And you should note this is not the definition of unlawful content is not in distinction to manifestly unlawful. Manifestly unlawful means it's unlawful content that on the face of it, it should be obvious in some way that it's unlawful. And notice here a real cultural difference in German law from American law, which is the use of Nazi symbols and propaganda. In U.S. law, the use of Nazi symbols and propaganda is protected by the First Amendment. Now, if it is inciting violence, if it is actually literally calling people to arms and to commit violence, that incitement is not protected by the First Amendment. But merely using a swastika or other Nazi symbol, or trading in copies of Mein Kampf, or trading in copies of neo-Nazi propaganda, is protected by the First Amendment, as horrible as most of us think that content is. And in German law, for historical reasons, obviously, it is not. And, in German law, it's not only kind of neo-Nazi skinhead type groups that this is geared at, although that is a significant problem even today in Germany. But even things like historical memorabilia and the like, trading of those things is unlawful. Encouragement of violence, endangering peace. Endangering peace, that's a pretty broad thing. I mean, some of these, incitement crimes could be crimes in the U.S. as well. Incitement of hatred, this again is a really broad category. What does incitement of hatred mean when you're talking about a religious group, ethnic origins, speech that in the U.S. we might consider morally offensive because it's racist, but we'd still consider protected by the First Amendment, potentially violates this German law and therefore potentially requires the service provider or social media company to take it down. And likewise, for simply insult, slander, defamation. I mean, insult. If you think about social media and the category of insult relating to some sort of characteristic like gender or race or religion or philosophy, that's a pretty broad category. The penalties under the NetzGD law are potentially substantial, up to 500,000 euros for failure to comply. And providers are required to designate an agent for service of process. This means even if the provider is not a German company, it must have an agent in Germany to receive process and so that it's able to comply with the law. Now, this slide here is showing you a piece of Google's transparency report, and if you look up Google transparency reports, they provide these for different areas in which the company is required to comply with legal requests for process in different ways. And this one is specific to the NetzDG law in Germany and specific to YouTube, and you can see the reporting period is the first 6 months of 2021, and if you can run this report for different areas, different law, different countries, different elements of the Google service, different time periods. But just to give you an illustration, the NetzDG law allows a government agency to report and require a takedown. It also allows users, individual users of the service, to report and to require takedowns, and of course requires the company to requires the company to have procedures in place. So, within that 6-month period, 200,000 takedowns from user-generated requests, about 100,000 takedowns from agency requests. Now, maybe that's not a lot, in terms of the overall volume of material on YouTube that's available in Germany, but it just gives you a little bit of feel for the way this can be used. Now, again, some law enforcement groups, some advocacy groups concerned about hate speech and the like think this is a good thing. Some civil liberties groups and cyber civil liberties groups think these laws are really bad. They're particularly concerned about potential over-reporting, even false or malicious reporting that gets content taken down. The idea that a user can inform on their neighbor, so to speak. In some cases where it might really be truly horrific kinds of content, but in other cases where it might not. And the role the social media company has to play in relation to the government is questioned. So let's look a little bit at the law in France. And again, I didn't give you all this to read, but I want to summarize it for you a little bit. So there's a number of different overlapping laws in France that we could look at. In 2014, France passed an anti-terrorism law, which is a really strong anti-terrorism law. And as you know, as in Germany, France has had some significant problems with terrorist incidents on French soil. So it's a real concern. And there's a real difficulty in France, as you probably know, kind of balancing that out against the problem of Islamophobia and in relation to European issues about migration, particularly from Syria and from northern African countries. But all those big issues are tied up in these questions. So Like in Germany, Holocaust denial, of course, because of the Vichy history and the history of collaboration in France, is unlawful. But other kinds of terrorist content as well. There is a French central office that manages these requests and requirements. That office can require a site to block material involving terrorism or child abuse. After a 24-hour sort of voluntary period, it can issue a mandatory requirement, and it can require that search engines delist content involving terrorist content or child abuse. Now, again, the child abuse is, I think it's relatively easier to define what that means. The terroristic content, on the one hand, it can be easy to define that. On the other hand, as you get more and more toward questions of ideology and other sorts of things, maybe it gets a little more difficult. There was another law passed in France in 2017 that criminalized individuals habitually accessing online services without legitimate reason, which include terroristic type content. So whereas the 2014 law primarily goes at the service providers, the 2017 law went at individuals and their conduct online, and it was a way of also allowing the government to monitor the activities of certain individuals online, and not just the speech they were doing, but the sites they were visiting. That one, actually, the French Supreme Court, French highest court, declared unconstitutional under the French Constitution. So you can see there is, in France as well, as we have seen in the US with FISA and other things, constitutional questions about some of these laws. And of course, the French authorities are still very actively prosecuting online terrorism issues, and it does tie to all of the kind of broader cultural and civil and even international questions we've been talking about. I gave you to read a European Court of Justice case involving France, and this involves another French law, and this was the French law that allows the authorities to engage in internet surveillance. And again, I didn't give you all the details of the law to look at, but it's a lot of these provisions are similar to the kinds of things we have in the US. Of course, something similar to search warrants, but also things that are more similar to the Electronic Communications Privacy Act orders that are on some lesser standard that allow the government to gather stored electronic information and to intercept information in transit, and also kind of similar in some ways to the US FISA process. So if you remember, I mentioned to you in class last week, the EU criticizes the US for FISA and the way that statute is used in internet surveillance in the US, but the European countries are doing many of the same things, and most certainly Germany and France are doing many of the same things. So this is many of the same things. You can see when you read the opinion that many of the issues raised are similar to the questions that are addressed by the US Supreme Court in the Carpenter case. Of course, the Fourth Amendment context in the US is different, but it's a similar idea of constitutional civil rights and the scope of the surveillance that is possible in the internet age. And when you read this opinion from the European Court of Justice, and remember, this is now the European Court that is deciding whether national law, in this case French law, is consistent with the guarantees of the European treaties that govern all of Europe and the individual rights that are given to citizens in Europe under European treaties and directives and regulations. And those European treaties recognize a fundamental right to privacy, and that fundamental right to privacy supports the European General Data Privacy Regulation, the GDPR. And this is really different from the more limited understanding of privacy rights that arise out of the US Fourth Amendment. And this is a real difference between how the EU on the one hand and European countries and the US on the other hand understand the notion of privacy and how it relates to basic human and constitutional rights. In the EU, it is a much broader fundamental kind of right that extends to many different domains. In the US, it's a more limited kind of right that primarily relates to government search and seizure and the warrant requirement, and that, as we have seen, is much more readily disclosed or defeased from a person through the third-party doctrine, right? So Carpenter kind of pares back the third-party doctrine a little bit in the U.S., but the notion is much broader in the EU. So a couple of things that this opinion does as you read through it. The national legislation to do surveillance, online surveillance, for combating serious crime, including terrorist crime, is a national interest, and it does have to be balanced against this fundamental right of privacy. But what the court is saying is that it should not, the government's ability to conduct this kind of surveillance should not go beyond what is strictly necessary for the law enforcement purpose. And that strictly necessary, you can kind of look at that like a kind of constitutional strict scrutiny, which could be applied to certain things in the U.S. in a kind of analogous domain. So the European Court of Justice lists some restrictions and ways in which the surveillance has to be specific and targeted, and not sort of a general warrant for surveillance as seemed to have been occurring. Likewise, and I think this goes a bit beyond what the U.S. has addressed so far, automated analysis, so using artificial intelligence or other forms of computer automation to look at patterns and to predict those patterns, and in particular to do that on criteria that relate to racial or ethnic origin or political views or religious views and other things, has to again be very, very tightly controlled, and is likely to infringe that fundamental right of privacy. So it can be done, but it has to be specific, it has to be targeted, it has to be strictly controlled and supported by specific reasons. All of these categories, by the way, that are listed here are things that are considered to be sensitive information under the GDPR. So this decision of the ECJ is tying these limits on government surveillance to the kind of rights that are recognized in the GDPR. So in the US, automated surveillance, automated analysis, you're using profiling through artificial intelligence, is not really directly addressed in Carpenter. Carpenter addresses the information about individuals that's gathered from a third party, but it isn't really addressing the kinds of profiling that can be done based on public information. There have been cases here and there, not at the Supreme Court level, that have challenged racial profiling of different kinds on equal protection grounds with some degree of success. But I think you're going to see both in legislation and in litigation sort of more questions and challenges about artificial intelligence-based profiling of all sorts of different kinds. And I don't know if the results are going to turn out exactly as they did in this ECJ case, which really is constricting the ability of European countries to do that kind of profiling. And so this slide really summarizes the conclusions of the ECJ opinion, right? And these are the key phrases: targeted, time-limited, subject to judicial reviews. So it can't be a general, broad purpose sort of warrant. It can't go on forever. And there has to be some recourse to courts looking at it. And in the case of automated analysis, subject to prior judicial review, and that's really significant. So it's requiring a court to look at the automated stuff before it even happens. We certainly don't have that kind of requirement exactly in the US at this point. Now, the last piece for comparison we want to look at is the Australian violent material statute, which I did ask you to read. And this was passed after the live-streamed mass shooting in a mosque in Christchurch, New Zealand. and it deals with material that records or streams abhorrent violent conduct, and there's some definitions of what that kind of conduct is, and it will require, it doesn't matter if that material has been altered in some way. It doesn't even matter if the conduct occurred in Australia, so long as the streaming of the material is available in Australia. And it makes it a criminal offense for an internet service provider to fail to refer that kind of material to the police. So it again obligates social media companies, YouTube, Facebook, and so on, to have people and technology that are screening for this kind of content, and that are then referring that content to the police. And again, it doesn't matter if the service itself is provided within or outside of Australia, so long as the material is available in Australia. And further, makes it a criminal offense for the provider to fail to expeditiously remove the material. And this is any material that is reasonably capable of being accessed in Australia, which of course, if it's on the internet, it's accessible in Australia. Now, another key piece of this is, what's the duty on the provider to actually detect material? And the standard that the Australian law comes up with is recklessness. So if you think about possible standards, you have intentional, which would be a very high standard. You'd have negligence. You'd have intentional, which would be a very high standard. You'd have negligence, which would be a somewhat lower standard. And then somewhere in between there is reckless. So this is not necessarily intentional, but it is having some knowledge that the material is available and was not discovered. And it raises questions about, what we call red flag knowledge. In other words, even if you don't know of this specific content, do you know enough to know that you should have known that this content was available? And it puts a high obligation on the provider. Now, there are some exceptions built into it for certain research purposes, for artistic works that potentially could cross a line that someone might think is a line. And cyber civil liberties groups, again, were and are very upset about this law in Australia. Many law enforcement groups think it's a good thing. Many cyber civil liberties groups thinks it goes too far and places too many obligations on the provider. So some proposals or some things to think about as we move into our discussion forum for the week. So, there are different ways that you can deal with this problem of terroristic hate speech, fake news content, as we've talked about already a bit in the U.S. context. I mean, we could make compliance simply voluntary. We could provide incentives, a seal of approval, a certification, an immunity, or a safe harbor that you get only if you comply. Right? Most of the civil liberties groups, cyber civil liberties groups, want simply voluntary compliance. You could have mandatory compliance, as we've seen in some of these laws, and that can include potentially a criminal offense. And think back to our principles of criminalization and whether we want to have the intermediaries, the media companies, be criminally culpable for this, either for failing to remove or for failing to monitor. There's other things that have been proposed. We could have a certification program by the government that looks a lot like censorship, however way we look at it. We could have registration requirements for the users of a site, which may do something to help law enforcement track people down, or maybe not. And of course, by registration we mean real identifiable information, which would destroy anonymity, and it raises all of the questions that we have about anonymity. There are some other possibilities that we haven't discussed and that we're going to talk about more when we get into the materials next week on countries outside of liberal democracies. So you could have requirements about data localization. You could say to the provider, if you want to offer services in our country, then the data that you're making available, that you're streaming, whatever, has to be localized on servers within our jurisdiction, which allows law enforcement in our jurisdiction to shut down or take control over those servers if you don't comply. There have been some advocates of these kind of rules. As you can imagine, they're highly controversial. Number one, because they really break the cloud. That's not how the cloud works. Number two, because it gives governments a lot of control. And likewise, government filtering and blocking. And this can also relate to the government itself providing core parts of internet infrastructure, like internet exchange points or IXPs, and the government controlling those sort of high bandwidth pipes in order to protect these aspects of public safety, but also then to otherwise engage in surveillance and in censorship that happens outside of liberal democracies, and that even countries like Germany or France with very strong laws about terrorism and hate speech would find really problematic. And that's the kind of thing we'll begin to look at next week. So we'll talk about some of these things, and in particular we'll talk about the German and the French and the Australian laws in our discussion forum this week. And so I look forward to seeing you on the discussion boards. I hope you have a good Thanksgiving, and then I'll see you in person next week.